Welcome to the Meaningful Mediation Podcast, the place where leading lawyers and negotiators share their best tips and strategies for mediation and negotiation. I'm your host, Patrick Russell, a full-time Florida mediator and lawyer. My goal is to help you have an effective and meaningful mediation. Each episode will provide you with real-world strategies and tips to help you negotiate and mediate with confidence. Let's get to it. All right. Well, welcome back to the Meaningful Mediation Podcast. This is the show where we talk with lawyers, mediators, and negotiators for their best strategies and tips for mediation and negotiation. Every episode, I sit down with someone whose days are spent at the intersection of conflict and resolution. Today, my guest is Bradley Winston. Brad is the founding and managing partner of the Winston Law Firm in Fort Lauderdale. He is a board-certified civil trial lawyer, and for more than 3 decades, he has been a plaintiff side voice in some of the biggest personal injury and wrongful death cases. He has carried cases through jury verdicts, through appeal, through mediation, and through every kind of adjuster conversation you can imagine, which is exactly why I wanted him on. So, Brad, welcome to the show. I'm glad you made the time to be here.
Well, good morning. Thanks for having me.
Wonderful. So before we get into it, I want to back up a little bit and let you tell people who you are and how you ended up doing this kind of work.
Well, sure. Thank you for the excellent accolades and introduction. I grew up in a row house in Philadelphia, the son of a police officer and an emergency room nurse. And I just had to get someplace where I wasn't going to stand on the corner in the snow in the dark every morning. So went to college in Florida, and I have a bachelor's in health administration because I can't do math, even though I wanted to be a doctor. So I wanted to work with doctors. And that turned into a master's, and then I found out I couldn't make a living as an entry-level administrator. It was basically an office person. So I went to law school and worked in spite of not being allowed to work, and ended up being mentored by a couple of very adversarial small firm plaintiffs lawyers, and kind of thought that was the way that you were supposed to act. Ask no quarter, give no quarter, black letter of the law. I ended up moving to a general practice where they let me handle, as a law student, there are like 15 personal injury cases. And so I clerked there for a year, and then I was an associate for a year. And it dawned on me that I could do it. I could take a case from the first phone call all the way through getting the client the benefit of where to go for treatment, and then getting them whatever compensation was available. And it dawned on me that I was working for $27,000 a year doing this. So they gave me my 14 or 15 cases when I told them I couldn't stay. And I started my own firm in one room in an executive suite situation, and had 2 desks. My wife at the time was a paralegal, and she came to work for me. And she had to leave the room when a client would want to meet with me. But so I did door law. When you first start out on your own, if it comes through the door, it's law. Mm-hmm. So I interned in the public defender's office, so I learned how to do DUI defense. And there was a book that we called The Shtick. It was about 4 inches thick and 17-inch giant pages, and it had everything that you did to defend a DUI case. And this was before we even had desktop computers. It was in the 80s. And so I basically did what I did when I studied for the bar, which is memorize things. I could do that easy. And so I sent off to the clerk of the court for every DUI arrest report every week. And so there was, 500 or so. And I would sign a personal letter to each person, complying with the Florida bar rules, which made my signature into the unrecognizable hieroglyphic that we enjoy today. Um, the bottom line was that I tried 16 DUI cases my first year out on my own. So as a 2-year lawyer, one of the reasons I left the firm was they wouldn't let me do a jury trial. They would let me work one up and then settle it out from under me. So I tried 16 the first year out and got 15 not guilties.
Not bad.
Yeah, I was lucky to be able to specialize in what I love, which is personal injury and medical related stuff. My first civil jury trial was a medical malpractice wrongful death case, which I lost, and I learned a lot. But within 5 years, I was trying a dozen civil jury trials a year, which is just a tremendous amount. I mean, these days I do a much more intense job on much more complex matters, but I only have it in me to do a couple a year because really you have to, you listen to the masters talk about how you prepare, and it's even for a simple case, the last 10 days before the trial starts with turning every page and having no distractions and working from the second you open your eyes until the second you pass out from exhaustion at night. And it's the same when you're in trial. Between meeting with witnesses and preparing for the next day, I'll have 500 unread emails at the end of a trial because I just can't run the firm and have a daily life and have a family life when you're trying a case. So I don't know. I guess the big inflection point in my formative years was realizing that I could help someone and get them compensation on my own without the constraints of a corporate firm or expectations of the larger firms. So I always had a smaller firm that since I left, the firm was called Ruff and Karski. We had a very general practice. They did city attorney work. And since I left there, I haven't worked for anyone else besides myself. And I don't think I can imagine doing that.
Yeah.
But I remember the first mediation I ever had.
Okay.
There was a client that was a psychiatrist, and he was a professor of interviewing, counseling, and negotiating at Nova Law, where I graduated in '88. And we became friends. We fished, and he didn't dive. I was a big diver at the time, but we fished a lot together. And he had bought it himself as a consolation prize or as a pick-me-up after a family tragedy. He had bought a brand new fancy red Firebird. So I became a lemon lawyer.
Mm.
The battery would go dead because of an anti-theft thing in the radio, like every week. And so we did this lemon law, and I'm out on my own in this executive suite, the place with one room. And we go to this mediation, and there's all these big firm lawyers and gold Rolexes and, BMWs and Mercedes in the parking lot. And here I am in my Datsun pickup truck and a, off the rack Sims polyester suit and a little Pisha. And these guys bought the Pontiac back and gave me $20,000 for attorney's fees.
All right.
Under the lemon law. So it was like one of my specialties. I started doing lemon law cases now. But I couldn't believe how easily and quickly a year's worth of hard litigation with the most adversarial of defense firms was resolved with me getting a big check for my fee and my client getting made completely whole in a half a day. I have been a fan of the mediation process ever since. Unfortunately, I'm not suited to being a mediator. Someone like you or my brother Andrew, who's a full-time mediator, understand the process better than I do. I've seemed to jump to the result.
Patience, Brad.
Yeah, well, even that very first one, I can remember having to suppress or be told, don't leave after the first offer. I think in our mediations, you've had to tell me that.
Yeah.
Because I always feel like the offers should and the demands should reflect a good faith willingness to engage in the process. But for many people, I guess that means something different than it does to me.
Yes, and some people also look at it as a process and that we're going to grind it out because that's eventually how we're gonna break bread together at the end. So, there's different ways to go about it.
I did some studying of interviewing and negotiating, not just from that professor, but some self-help stuff and some. I'm big into business self-help literature and podcasts and recordings, audiobooks. And one of the rules of negotiating I learned was that the more anyone invests emotionally and financially and intellectually and time and effort that someone invests in a negotiation, the harder it is to walk away.
Mhm.
Of course, there's always what would you say, the spoiler on that, and that is if you're afraid to walk away from a negotiation, you've lost.
Yes.
So
What do they say? Um, if you want peace, you need to prepare for war.
yeah. Well, you also have to, you know, keep a kind of all the dynamics in play, and that's where a great mediator like you excels. I mean, I can't keep Sun Tzu in my head at the same time as I'm thinking about, practicing the wince, the flinch, and you know, the posturing. I don't. Yeah, as you can see, I have a very direct style. I have all these uncomfortable pauses when I speak because I choose words carefully. I, I guess that comes from having your own style. One thing I learned from some of the masters like Chris Searcy was you got to be yourself. For years, I tried to have that Jacksonville drawl, and it doesn't work for me.
I can't imagine that on you, Brad. Well, your firm has been handling personal injury cases since what, at least the late '90s
No, I went out on my own
or late
with,
late '80s, I should say.
yeah.
Late
I
'80s.
graduated in '88. I went out on my own in '89. Um, Incidentally, I quadrupled my income the first year. And as I began to specialize in personal injury cases, I was fortunate to foster a great set of mentors. One of the best things when I was younger was I was always told, don't be afraid to pick up the phone and ask a more experienced person how to do something. And people do that with me, and I'm always flattered that someone wants my take on a complicated situation. Um, there's no stupid question, but there are questions that indicate that someone hasn't done their homework. So, yeah, personal injury cases I mean, I did a very general practice, but we always tried to get the personal injury cases. Became a board certified civil trial lawyer in '97 because I was friendly with still those guys that I mentioned were very adversarial. Um, and they pressed that as an advantage, and it's served me well. I've been continuously recertified every 5 years since 1997. Rated, which is the highest rating in ethics and ability from a peer review standpoint for lawyers and judges. President of the Broward County Trial Lawyers Association. That was a wonderful experience. I followed someone who didn't take the position as seriously as I did, and so I revamped the whole thing. New board of directors, new charter, executive director. I was the one that hired Laura, if anyone knows her from the Broward County Trial Lawyers. We resisted the name change to the Justice Association that the politicos up in Tallahassee did. I was on the board of directors of the Academy of Florida Trial Lawyers uh, when they came around and wanted to change it to the Florida Justice Association. And although I was opposed to that, it did come to pass. So the ATLA, the Association of Trial Lawyers of America, became the AJA, and the Academy became the FJA. But I get that. I mean, politics is part of this, and we've been resisting tort reform uh, because it takes away our clients' rights, and I'm kind of a one-issue voter when it comes to that. I still try to help out in Tallahassee when I can. I've also been a motorcyclist for all my adult life, and I think we have a common core of couple of friends that are also motorcyclists and lawyers, and that's how we know each other. And I've been very involved in the motorcycling community. Can't ride, so you can see the wire sculpture behind me of the Harley. That was given to me by an orthopedist back in the 90s when he retired and closed his practice, because I openly admired it when I went to his office for a deposition. And so it's kind of been my thing. I was one of the founders of the now inactive, really. There's a National Motorcycle Lawyers Association that Rich Newsom and Steve Marin from Atlanta and I got going. Yeah, I'm actually legislative liaison and general counsel for ABATE Southeast. That's the bikers lobbying organization.
Mhm.
That's an association of brothers aiming towards education, or a brotherhood against totalitarian enactments, depending on who you ask for, ABATE.
Okay.
So yeah, I do a lot of pro bono work for them, and I'm a big sponsor. So
Well, getting back to, you mentioned it briefly. So you've been doing it a while. What have you seen change, say, since the late East till to now in your practice, whether it's jury tolerance, insurance behavior, culture, everything? What's going on in the personal injury world? What's changed?
it's certainly not what it once was. It's nowhere near as well. Technology, culture, professionalism, the rules, the courts, the judiciary has evolved into something that is feeling the courts, the judges feel a lot of pressure to keep their case counts low, move along, and keep the scheduling stuff. A case came out of the new Sixth DCA called Crescelius versus Risitano in February that basically said you can strictly enforce your scheduling orders without considering whether anyone is harmed. Prejudice, they call it. Yeah. Yeah, there used to be an analysis under a case called Binger where you would decide if a scheduling problem, not having a expert disclosed until the last minute, was going to cause somebody prejudice. And then the Supreme Court and all the 16 different district court opinions said you have to consider a balancing test of prejudice, which is legal harm and surprise, versus, the court's interest in efficient administration of justice.
So process is now more important than.
Oh, 100%. And look, the Supreme Court has changed the rules of civil procedure a couple of times in recent years to tighten up summary judgment standard to conform with the federal standard. I used to specialize in 1983 cases of deliberate indifference to a serious medical need of a prisoner, excessive force, false arrest. If you look up my name on the CMECF, Case Management Electronic Case Filing portals in the Southern District of Florida, there's something like 108 filings for me. And that stopped in about the mid 2000s because the courts were being appointed and the rules that were being enforced and the changes in the rules of civil procedure were militating so heavily against being able to efficiently handle those cases. You couldn't help these people anymore. I was there at one point, a stack of my business cards was circulating around the Broward County jail system, and I was getting these very typical handwritten letters from prisoners, and 20 cases a week I was turning down at one point because you just can't help everybody, even the most deserving ones. That's changed. I no longer enjoy going to federal court. I used to love to file a federal case because the caliber of jurist and opposing counsel would be elevated. They do practice at a higher level, and you have to know what you're doing. And the courts are familiar. I mean, if you said the words 1983 to a state court judge in the 90s, their eyes would glaze over because they hadn't been educated. There's a whole specialty to all of that stuff. But the U.S. district judges and opposing counsel who were practicing in the arena, they got it. So if I did a lemon law case and I wanted to add a Magnuson Moss Warranty Act count to it and bestow federal jurisdiction, I knew that I was going to Yeah, I was going to have to write a brief every time there was a motion, but I also had them in the can. And when I went down there, I knew that everyone was going to understand the cases and the statutes, which
Mhm.
is not the case in state court. You need to pass the Florida bar to go to state court, and that's it. It's almost like being a juror and having a driver's license. The amount of practical experience that is required to litigate anything in state court. Although I find in the complex divisions, we have some fantastic judges, and the lawyers who typically end up with complex cases are experienced and accomplished, and it is a pleasure to work on complex division cases. The general civil stuff and the family law stuff, I have friends that are judges that are sorely disappointed in the level of practice that is on display. I guess that's one of the things. I've always kind of prided myself on trying to be at the top of my game legally and strategically and procedurally and technologically. And that has kind of, I think that's what I attribute in large part the successful career that I've enjoyed. It's been equal parts of luck and hard work, I think.
Mhm. Probably more hard work than luck, though. So,
I didn't I didn't take a vacation for the first 10 years I was out on my own.
well, let's pivot to a different party in our justice system. Let's talk about adjusters. So, by trade, they are essentially professional negotiators. So, what has 30 years of dealing with them taught you how to actually move them off of their number?
You know, at the beginning of my career, I was offended by the word adjuster because if I have for instance, a property damage claim on a car, it's
Mhm.
going to cost a certain amount that I have no control over. Why does an adjuster need to adjust that? How does an adjuster affect that? It's viewed those folks in the cases where there's a set price on things as more of processors, the person who takes the documentation and evaluates whether the claim is sufficient to be paid. And as I got into cases with human damages, I
Mhm.
came to understand that adjusters have to evaluate cases just like I do. They are, number one, they're humans and they have bosses and they have to answer to a process. So it's my job as a claimant's attorney to give the adjuster everything they need to justify an evaluation that sees the case in a way that's not inconsistent with what I do. One of the first things I always tell a new employee here at the firm is you must read Dale Carnegie's How to Win Friends and Influence People.
Perfect.
And yeah, and from the reception desk to the runner to the bookkeeper, every one of them gets handed a paperback. They cost $5 on Amazon. And I give them $100 cash bonus if they're able to answer 3 or 4 questions that they would have to get from the book after they tell me they've read it. And it has worked. That book has as its basic premise that I've referred to winning a negotiation, and I think that's a misnomer. Nobody wins a negotiation. Um, there's only a win-win. You only walk away from a negotiation feeling like you want to do business with that person again because you're going to see them again, or you're going to see someone they know. You're going to see someone in their circle of influence, and you're going to have another negotiation with them. So my take on adjusters is not that they are the enemy, but they are an ally. They're a partner in coming to a win-win. I've got to give them what they need to get what they want. What does an adjuster want? Adjusters want to foreclose an exposure. They want to get rid of a risk. They manage risk. That's why they call the department risk management. My job is to get my client as much money as I can, as quickly as I can, with as little risk and exposure as possible also. So our goals are not inconsistent. They're totally consistent. Yes, we walk into a mediation. I want as much as I can. Very rarely will even tell the mediator what my walkaway number is because I usually don't even know what it is until after I engage in that process. And adjusters, as I think you'll agree, in a successful mediation is where an adjuster feels like, yes, I've been given enough information to be prepared, and I haven't been sandbagged here with new information. But in thinking about it over this process, I need to go see if I can get some more authority.
Mm-hmm.
And really, a successful mediation is where I think the claimant says, well, if you get me this much more, we can really get this done. And the adjuster says, well, I don't have it, but I'm going to make the phone call. And then someone who the adjuster has to answer to gets to make that call.
Yeah, I totally
So
agree.
yeah, adjusters, not the enemy. Defense lawyers, not the enemy. I try to think of defense lawyers as somebody who I'm going to ask to send me a check when we're done. Yeah, they have to make a living too, and they have to justify their existence. But I no longer will even take cases where I can't see myself sitting next to this person in front of a jury, because you have to believe in the case in order to be able to communicate that value to the attorneys and to the adjusters.
I think it's too often you see, whether it's a lawyer or an adjuster, treating a negotiation or a mediation as a one off. Like, burn the bridge. I just want this result at all costs. And like you said, it's a very small world.
Now, there are some hostile relationships that you just can't avoid. I had a mediation last week where I just told the adjuster, there is a walkaway number. I told him what it was, and the other side wasn't getting close. So I just had to say, we're not there. I'll see you in the trial. Was it frustrating? Yeah. But you and I've mediated many cases, and we've successfully done most of them.
Mhm.
So I've
I just
appreciated
need
your
to keep
approach
you
to it.
there.
Yeah. 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 I mean, there is that problem with getting frustrated. So,
Well, let's talk about that, the little preparation before. So you mentioned that you like to prepare. That is your hard work is one of your mantras of your success. So how do you prepare for a mediation as a plaintiff's lawyer? Walk me through what your process is and what
sure.
do you think most lawyers may skip that they shouldn't?
Well, the basic principle is that the decision makers on the other side, they need time to digest your material. My goal is when I get a mediation set, I try to get everything that I think the other side needs at least 30 days out. That's why you'll see from me, now I have summaries. I use FileVine with the AI, and I use Perplexity with the AI. And I do very detailed summaries of what the cases are about and what the damages analysis is. And I share it. I don't hoard it as work product. There's no such thing as springing anything on anybody in trial. I don't hold stuff back because I think that's counterproductive. So you mentioned it. Preparation is the key. A fancy detailed demand letter usually has been done a long way before. And then you need to get something of a summary together that has any of the recent developments. You can't walk into a mediation and say, oh, they just had surgery last week. Nobody's prepared for that, and it's not part of the evaluation. And if it's not in the materials that you provided to the other side in time for them to report on it to the adjuster, you're not going to get it anywhere. I won't mediate a case less than 30 days after the plaintiff's depositions, or less than 30 days after a key witness, like a physician or something, is necessary for evaluation, especially if I think it's going to go well. Now, I had a case, a brain damage case that I wanted millions for, that I just had to settle for 100 grand because the engineer that I hired did not do well in his deposition. And I was counting on that witness to really show the other side, who are engineers, that we were going to coherently make the case of the violations of the standards that I was being told all along. So now my client and I are lucky to get out with our skins.
Hmm.
So
One of the perils of being on the plaintiff side.
That case mediated twice and failed. Yeah, I mean, those are the vagaries of litigation. But I think the key is to make sure that the mediator has a detailed summary. I've been going back and forth about whether to do a fancy PowerPoint presentation. We also have a mutual friend who makes his living doing those. He's a trial consultant, and he's been pushing me to do these 40 and 50 slide mediations that take an hour to get through, 45 minutes. And I'm seeing the attention span on the other side is about 15 minutes. So they've got to have the materials. They've got to see that I can make the points, address the defense points in 15 minutes, and the damages. You got to do liability and damages in less than 20 slides and finish your talk in less than 15 minutes. And if you can do that, at least you will have communicated to the other side that you're prepared and that they have the materials that they need.
I agree. Obviously, I hear from both sides a lot, and it seems a consensus from what I heard on the defense side is they prefer shorter openings. And when they may drag on for an hour, they're not happy about it.
Well, they stop listening. They start doing other things. We're all doing this by Zoom.
Yeah, their idea is that, hey, we already know the issues, but maybe their client hasn't heard it from you, right? So if you can make those points in a great summary that hits all the major points,
Yeah.
mission accomplished. So yeah, I
Yeah.
tend to agree that the shorter the better, but obviously you can't skip the basics, right? Now let's pivot over to the mediator side. What's your read on when a mediator is adding real value in a case versus when they're just carrying numbers?
I don't know. Honestly, I know some mediators get accolades. I think the ones that point out the flaws in your case and make you understand your risks of not succeeding on the merits for good reasons. I think that's the mediator's job, is not only to take the personalities out of the negotiation, but to ask incisive questions of each side and say, what if this happens and what if that happens? And let people understand that their entrenched position is perhaps assailable. I often walk into a mediation or Zoom into a mediation with a a cocksure position that I haven't thought about a vulnerability. And a good mediator will uh, gently manipulate me into thinking about that. However, the opposite kind of is true. If a mediator comes in and starts beating on me about what I already know, that goes in one ear and out the other. I'm sorry. So I think the way that you approach mediation with the kind of mindfulness strategy, trying to be thoughtful about what the parties should and shouldn't be considering as dynamics, that's great. One of the things that I think that frustrates the parties is if a party doesn't consider the cost of proceeding as part of the risk benefit analysis to resolution. There are certain insurance carriers, there are certain business entities that act like it's their own money and they have a principle to prove. You see that often with very young attorneys who are, as I say, unduly adversarial on either side. But it seems that the more experienced the attorneys, the more reasonable they are in terms of considering the vagaries of litigation. So yeah, I can't do it. I can't be a mediator because I'm too results oriented. I mean, I can hardly do a direct examination and lay a foundation because I just want to ask the ultimate question. 38 years of doing jury trials, and I'm still jumping to conclusions in front of the jury. And the foundation is always getting sustained objection. So that's why I love cross-examination. I could just say, well, isn't it in fact true that this happened? And there it is. So
Yeah. Well, I want to switch gears for a minute. So every guest on this show gets to basically describe what I would call the defining moment. You kind of started off on some of that earlier, but I'm going to ask you if you had to pick one case or even a situation, a life situation, doesn't have to be a legal case, that taught you something that you still carry with you today. What is it and what did it teach you?
I got divorced about 15 years ago from someone who was very materialistic. And for the last 10 or 15 years of our very long-term marriage, it was almost a competition to see who could retain as many material things and spend as many resources as they could. And my current wife taught me that things don't matter. Material things don't matter. You don't. The only thing that you really leave behind is the love. So that has translated to my law practice in a big way. I no longer will take a case just because it is perhaps a moneymaker. I learned that from a couple of great lawyers too. You've got to care about getting some justice for someone. And once in a while, you really do get a chance to see some justice being done. If you can get involved in a case where someone's really deserving and get them a result that literally changes their life, there is just nothing like that.
Well, I think that's very excellent because you can't take anything with you when you're gone, right? So it's really today's experience and what you're going to do tomorrow, how you
Yeah,
live.
exactly. The finest moments I've had is when I've rung the bell, but for someone who's now profoundly injured or disabled and is never going to have to work again, and their kids are going to college, or suffered a loss of a loved one, and those kids are never going to have to work again. I mean, and it's because of the imagination that a claimant plaintiff's lawyer has to bring to it, and the perseverance, the level of practice, and being able to play the chess game to the point where all the pieces have aligned and you really made a difference for someone. Yeah, I know that everyone does small cases, but I'm literally trying to only take cases now where I can make a difference.
Well, it's very noble. And I like the mentioning, obviously, of chess pieces because a lot of what we do it's definitely not checkers, right? It's on a different level. But let's get a little more practical now. I want to open up what I call the mediation toolbox. So, what is the one thing you always do before you walk into a mediation?
I always do a mediation summary for myself that nobody sees but me. It's got the salient facts, it's got my expenses, it's got the liens, it's got a couple of themes of the case, and it's got the negotiation history. I also have that in a spreadsheet with those factors that I can, and also a calculation spreadsheet, which puts the attorney's fees, costs, and liens into a formula because the client always wants to know, but how much do I get?
Hmm.
So I have an XLS that has a midpoint calculator for when there's brackets and has a client net rough out. So if X is the offer and Y is the client net, I'm able to tell the client that in real time and even show them, if I want to share screen, how the numbers work. If we get you this, this is what you get, because X and Y are the variables. So I won't go to a mediation without having that prepared.
That is phenomenal. Of course, I hear it all the time, as I either am coming in or leaving a room. So how much does that mean I get, right,
Yeah.
from the plaintiff side?
Well,
What's
that's what
the
matters.
number? And then it might take 20 minutes for somebody to figure that out, but it seems like you already have that with your calculator ready to go.
Yeah. That you have to be able to do that in real time because nothing must annoy a mediator more than being told that a plaintiff's lawyer doesn't know how much the liens are. Come on. That hamstrings everyone.
Yeah, it affects the net for sure. So, what do you think is a habit or technique that new lawyers get wrong in mediation, and what should they do instead?
I only know what new lawyers do these days when they're on the other side.
Uh-huh.
I think that when defense lawyers give a long, detailed presentation, it's almost always a mistake. To flip that on its head, one thing that I appreciate when defense lawyers do is if they point out something in the medical documentation that I hadn't been aware of that is helpful to them, because that affects my evaluation. And if they point out something in terms of a legal defense that I hadn't thought of. But if you take me through jury instructions, if you take me through testimony that I've personally been participated in, that's not helpful. I think that's a mistake. And I think I see more of that from the young lawyers. I also know that when a young associate at a defense firm is taking my client's deposition, that it's going to be long and repetitive because they're afraid of being yelled at for overlooking something. So I typically don't even attend client depositions anymore because life's too short.
Getting back to your refocus. Yes. Okay. All right.
So yeah, I mean, mistakes that lawyers make in mediation, I guess I learned not to do a long presentation because it's not appreciated. And I don't want it done to me either. I also think it's a mistake for them to begin a mediation by saying, we're not going to make a presentation. We're not
Mhm.
going to tell you our perspective, but we're here to negotiate in good faith.
Yeah.
Uh, for me, that means that you accepted as true everything I've just said. That's usually a mistake that I make.
Or what about the reverse? What about lawyers that hold back from mediation, some sort of thing that would affect your case, but they think they're going to launch it upon you at trial? It's the ultimate ace in the hole. So we're not really here to settle the case, maybe. We're not going to tell you about it. We have a certain number, but then we're going to really try to catch you, at trial. What do you think about those tactics?
Look, there are certain defendants that don't settle cases. And so overly preparing and making a fancy presentation at those is total waste. But the most effective tactic that has ever been used on me in a mediation was an in-person mediation. They handed me a manila envelope of surveillance photographs of my client lifting something that she said she couldn't do in her deposition.
Hmm.
And that case settled on the spot.
Yeah, as it probably should.
Yes. But if you can show me that my client is not credible or that I'm facing a dismissal for fraud on the court, I'm out of there. I'd like my costs, please.
Yeah.
But holding stuff back for trial is only done by the defendants who are not there to settle. And that's why I've led the answer with there are certain defendants who just don't settle cases, and it's important to know who they are.
Okay.
because you're being pulled into mediation as a discovery tool. They want to know what you've got, but they're
Yeah.
not going to show you anything. Can they do it? Yeah. Um, so the art to dealing with that is more in knowing the reputation of the defense lawyer and their client for resolving cases. If they don't settle cases and they try everything, then what's the point of mediating except that you've been ordered to be there?
Well, you literally beat me to the question about a technique that has been used against you that you appreciated. So let's move on to this one. What is a one tool resource or a book that has made you better at resolving disputes?
How to Win Friends and Influence People by Dale Carnegie.
All right.
Also, The 7 Habits of Highly Effective People.
Fantastic. I don't hear that enough from lawyers, but that is an awesome book.
It's dense. If you read it in its original format, there's not a wasted word.
Mm-hmm. Yep.
But there's also something that I found in my daily practice that I kind of showed everybody. And this is Militant Time Management for Lawyers by Ben Glass.
All right.
And he distills some of the 7 habits into a real-time, real-life application for lawyers. It's wonderful stuff. If you have a minute, I'll tell you about it in a nutshell.
Sure. Love to hear it. It can help, definitely help our listeners. So tell us.
Sure.
The title
Well,
might be a little offsetting to some people when they hear militant, right?
and that's actually a play on Dan Kennedy's business philosophy books, which is about ruthless management of people and profits and that kind of stuff.
Mm-hmm.
For years, I was a student of business philosophy because I wanted to more efficiently run my law firm. But the most important thing is time. It is the one thing that you don't get back. You have a certain set of tasks that you need to finish in every day. And everything that distracts you from that means that you're going to work longer that day. And take it from someone who has worked plenty of 18-hour days. Every minute that someone wastes for you is another minute that you don't spend with your loved ones. Getting back to what's important in life. So if you think of time, your work time, as a set in a circle. You remember the old Venn diagrams with circles?
Mm-hmm.
Not sure if I can. So it's not coming out very well on the camera.
All
That's
right.
a
See a
circle.
big circle. Yeah.
Yeah, that's your time that you have to spend today on
Okay.
work. And in it, you have to fit everything that you have to do. And for the concept of militant time management, you divide it into quadrants. Quadrant 1 is things that are urgent and important. Quadrant 2 are things that are not urgent, but they are important. Quadrant 3 are the things that are not important, but they are urgent. Quadrant 4 are the things that are not urgent and not important. So the factors here is whether something is urgent or it's important. And so here's what the quadrants look like. Quadrant 1 is urgent and important. Quadrant 2 is not urgent but important. And quadrant 3 is not important but urgent. And quadrant 4 is not urgent and not important. Got it?
Got it.
So quadrant 1, urgent and important, those are emergencies.
Mm-hmm.
Those are stop the presses, drop everything, do it now. You don't want to work in quadrant one if you can help it. It's stressful, and it means that other stuff's not getting done. Quadrant two are things that are not urgent, but they are important. And that's where you want to work. You want to work at your own pace on the important things and value that time. That's your real quality work time. Quadrant three are things that are not important, but they're urgent. Those are the people that stand in your office door and you say, got a minute? And it takes 15 minutes for them to talk to you about something that is not going to affect your productivity. Those are your emails. Those are the time vampires.
Yeah.
Quadrant four are things that are not urgent and not important. Those are scrolling social media during work time. If you catch yourself doing that and it's not because you need a break for your mental health, then you're doing it wrong. If you have an employee that is doing that, you should fire them. So the goal is always to work in quadrant two at your own pace and as productively as possible, and to avoid the interruptions. There's been a study that the average executive employee is interrupted 15 to 20 times a day from a task that they're concentrating on. And that takes time to reset, even after you get done with the interruption.
Exactly.
So the best advice I have on helping to run a law practice as any other business is set forth in that Ben Glass book, The Militant Time Management, and these 4 quadrants of work time. That's from the 7 Habits of Highly Effective People.
There's so many different varieties of that, but that one is a very useful one. You have the Eisenhower matrix.
The
There's a
4-day
bunch out
work
there.
week.
Exactly. And they all state the same thing, so it's a good template to follow because definitely the multitasking, the switching of context, the innocuous, "Let me just look at this for a few minutes," takes up
Mhm.
a lot of time.
And remove thank you and you're welcome emails from your practice.
Yeah, those are just extra conversations and possible responses. So you've given me a lot of good material, and this was, I guess, a bonus one, Brad. So I want to break it down to the final one, which is my top 3 tips for better negotiation outcomes. So if you could only have 3, what would they be in terms of the best ones to get better negotiation outcomes?
Number 1 is make sure the other side is prepared with all the material and hold nothing back. Number 2 is make sure your client has their expectations managed because every case has flaws. Number 3 is never be afraid to walk away.
Okay. And that again is going back, being prepared to litigate if needed.
Yeah, I mean if you're willing to take whatever they're going to give, then your case doesn't deserve your time.
Kind of like, again, the concept of if you want that peace, if you want that settlement, prepare for trial, right? Instead of if you want peace,
Yeah.
prepare for war. If you want settlement, prepare for trial.
Yes, if you are not prepared to try the case, then that will be communicated. Even if you try to avoid it, somehow the other side will understand that you're not a serious person. And, earning the respect of your opponents, that's the key.
So, Brad, before we sign off, I want to make sure that people who want to follow your work or send you a case know how to find you.
Oh, that's very kind. We have an AI receptionist and a live receptionist, and our main number is 954-9666. We have an intake email that is info@winstonlaw.com, and we have a pretty well-developed web page. It's very robust at winstonlaw.com. You can follow us on LinkedIn, Twitter, X, Facebook, and I think there's another one. I have someone manage the social feed, and I have a personal Facebook, but please don't message me on it because I don't do business on social media. But feel free to reach out any of those ways, including messaging me on Facebook, which will get me to send your information to a case manager. So we're happy to evaluate any inquiries. We do concentrate in personal injury and wrongful death. We specialize in roadway defect litigation. Those are where something wrong with the roadway, either maintenance, design, or construction, lighting, or traction, or something like that, has caused someone to be hurt. We very carefully screen medical negligence cases, but rarely accept them. Product liability cases, tire cases. I'm also a pilot and a diver and a motorcyclist, so I understand all these things intimately. And I'm happy to consult, and we pay the referral fees from the attorneys.
Very good. Well, Brad, thank you so much. 3 decades of this work and sharing your wisdom and craft with us has been a real gift. So I really appreciate you.
Well, thank you for having me. I know you and I have been talking about it for a while, and we know each other for at least almost 3 of those decades.
Well, thanks again. And if you enjoyed this episode, please hit follow on Spotify, Apple, or wherever you listen. And if you're watching on YouTube, go ahead and subscribe and drop a comment. This has been the Meaningful Mediation Podcast, and we'll see you on the next episode.
Thanks for having me.
We hope you enjoyed this episode of the Meaningful Mediation Podcast. If you did, be sure to like, subscribe, and comment. Additional episodes can be found on YouTube and your favorite podcast channels. Until next time, less dispute, more resolution.